Welcome back to The Heat. The United States government also uses the principles of forfeiture to reclaim hundreds of billions of dollars in civil and criminal cases. Under the forfeiture laws, U.S. attorneys are able to seize funds in an effort to bring restitution to victims. Well, let's get back to our distinguished panel. Let's go to Eapen in Kansas City. Eapen, we just heard Stefan tell us there that in 80% of the cases, the forfeiture is not contested. It's almost a cut and dried criminal case when these assets are taken away from people who supposedly or purportedly committed a crime here. So what's wrong with that?
So there's a couple of things wrong with that. First off, by bifurcating the process so that people have to challenge the civil forfeiture of their property and concurrently either threatening or putting people through a federal criminal process, you force people to play in two arenas for essentially the same activity. So, you know, let's say, let me take the case of Jimmy Thibault. Jimmy Thibault was a musician in Missouri, actually, and he owned a festival property, and it's a fact, you know, people went to that property during festivals and sold drugs there. But the government actually allowed Jimmy to stipulate this in the process that he went through, that Jimmy Thibault had done nothing wrong. Yet, the government initially seized his 350-acre property. They took money out of his bank account that was legally obtained through festival proceeds and receipts at the gate. And they put him through about a year-long process where they really pressured him to not contest the forfeiture of his land. Only after that process was going through did they actually charge him, and they charged him under a federal law that allowed, essentially the crack house statute, that criminalizes the ownership of drug-involved property. So someone can come to my property and sell drugs on it, and suddenly I'm exposed to a federal law that allows me to be put as a felon, and separately my property is taken. Now, when you take property in a federal civil forfeiture, it's also not, it doesn't make sense to challenge the forfeiture unless the value of the property is greater than the property seized. And Mr. Cassella says this nice thing about, oh yes, you can have your attorney's fees if you substantially prevail in your forfeiture case, but you know what? Number one, that assumes you have money or a good enough case that an attorney is willing to take that case on contingency. And number two, Mr. Cassella knows, and he's being disingenuous when he talks about the attorney fees provision of the law. Mr. Cassella is being disingenuous here because the federal government does everything it can to challenge fee awards. You know, we filed an amicus brief in I believe, a Ninth Circuit case where the attorney, a specialist in asset forfeiture law, spent about 100 hours trying to bill $500 an hour. You know, the judge, on his, you know, at the behest of the government, cut that fee award down to about $5,000. You know, what incentive do attorneys have to pursue forfeiture cases when the government vigorously contests their fee awards like this? It's a rigged system, and the end result. You know, and I think Mr. Cassella is being genuine when he talks about, you know, the desire to enforce law and the desire to uphold public safety, but this is just the wrong way to do it. You have a process that does not safeguard American constitutional rights and makes it far too easy for the government to rig the system. And that's one of the fundamental problems. And the other fundamental problem, which Mr. Cassella did not address earlier, is the simple notion that suddenly you have the government, the executive branch, self-financing its own activities, and that disconnects a whole host of legislative and constitutional checks and balances on the process. And that's a dangerous system to have in a democracy, in a representative democracy. Okay,
Stefan, I'm going to give you a chance to respond to what you just heard there, but I want to go to Richard. Richard, do you think that the system is fair? Do you think that you have a fair crack at justice when you see the manner in which asset forfeiture is conducted?
Well, I agree with Mr. Cassella in that forfeiture, along with incarceration, provides a very powerful deterrent and a strong message of deterrence to individuals out there who are indexing their own decisions of the benefit of participating in crime versus the consequences and probability of getting caught. So I think it's a very powerful tool in the Department of Justice's toolbox. I think the challenge, and I think Mr. Cassella knows this from his Department of Justice days, with respect to foreign bribery, is there's a challenge in trying to return those funds to the victims, particularly where the victims reside in a country that continues to be corrupt. So if the proceeds of crime are identified and the government tries to return it to the victims in country, and that country is still corrupt, it's almost an upside-down refund for a corrupt country. But there have been some very interesting initiatives, particularly through the Department of Justice Kleptocracy Asset Recovery Initiative and the World Bank Stolen Asset Recovery Initiative, where they're working with international monitors to try to return these funds in a way that helps local education and healthcare, but it's not necessarily returning those monies to the corrupt coffers, so to speak. And there have been some great examples in Kazakhstan, in Equatorial Guinea, where we've managed to do that with international oversight.
Right. Stefan, there were some interesting points that Eapen brought up there, sure. One of which was how the law is applied. He cited the example of someone, say, owning property. Or let's put it this way, someone owns a hotel. In that hotel, there are guests who either deal in drugs or use drugs or whatever. Is the owner responsible for that?
The owner is responsible, but he has an innocent owner defense. Congress amended the forfeiture statutes 15 years ago to address a lot of these concerns that we're hearing today. It's as if our critics don't realize that this set of reforms was enacted 15 years ago. Until 2000, there was no defense that an innocent owner could raise. The Supreme Court of the United States had held that there was no constitutional right to an innocent owner defense. We in the Department of Justice drafted one, and it was enacted by Congress. So a hotel owner who doesn't know that his guests are being using the property for drug distribution would have a defense. He would just have to show that he did not know this was going on, or that he called the police and took reasonable steps to stop it. But Eapen made some other points. Yeah. One was that defendants in criminal cases are being made to fight in two arenas. It's ironic that the critics usually say the problem with civil forfeiture is that there's no criminal conviction. And now we hear that the problem is that there is a criminal conviction, only that it's in a separate case. The fact of the matter is, from the prosecutor's perspective, it's much more efficient if there's a criminal case to do the forfeiture criminally. It's one-stop shopping rather than having to prove the case all over again, and in fact having to prove more in the civil case than you have to prove in the criminal case. In the civil case, you have to prove not only the crime, but the connection between this particular asset and the crime, which is a additional burden.
What about the other point he made, that in many instances it's very expensive, this process, to recover the assets that have been seized?
That's right, and that's why Congress, again in 2000, enacted this provision in Title 28 of the U.S. Code that allows the successful property owner to recover his attorney's fees. And yes, by all means, the government resists the attempt to recover exorbitant attorney's fees. I can recall a case from a few months ago where, in a case involving just $14,000, attorneys billing at $650 an hour were running up hundreds of thousands of dollars in fees. And those are fees the taxpayers have to pay if the court finds that they are reasonable. And it's natural that the government, in its interest of protecting the public fisc, would resist those exorbitant fees. I can't recall very many cases where we were successful. Judges tend to let defense attorneys recover $650 an hour. And as a prosecutor who used to make $75 an hour, I can tell you that that was somewhat grating when you saw that happen.
Okay, I want to get to Eapen very quickly. We're running out of time. Eapen, what about those provisions of the asset forfeiture law that allows for restitution to victims? Do you have a problem with that?
Well, I think it's good to have victim compensation, but the fact is, and Mr. Cassella knows this, is that there are forfeiture cases out there where victims have sued the United States federal government because the government was trying to prioritize distribution of forfeiture proceeds to law enforcement before they took care of victims. I also want to rebut a second point that Mr. Cassella brought up. Mr. Cassella noted that 15 years ago we changed the law to provide an innocent owner defense, but Mr. Cassella also knows that in the recent case of the Motel Tewksbury, or the Motel Caswell in Tewksbury, Massachusetts, this law was, the government ignored the law. The government went after a hotel owner who had cooperated with law enforcement, who had never been accused of doing anything wrong, but they forfeited his $1 million property because they believed they could take it. And the reason why that property was seized in the first place is because the government had a contractor looking for properties to seize who went through old arrest records and said, hey, someone got arrested at this hotel 7 times over a 10-year period, so obviously there's a nexus of drug dealing and this hotel, let's seize it, regardless of the innocence of the property owner.
Right.
We helped with the research in this case and helped make this argument in federal court with the Institute of Justice.
Okay.
And the federal judge pointed out to us that, yeah, we were correct. The
Lots more to talk about.
This, but
Right, lots more to talk about, but regrettably we've run out of time. Eapen, Richard, and Stefan, thanks to all of you for joining us.